This legal educational commentary, and today will be the day I earn that subscription. For today's stream, I want to respond to a Legal Eagle video. It's been a while since I've done one of these, responded to a Legal Eagle video, but I'm here for it. I'm here for it because he is upset about the death of Chevron. I am less upset about the death of Chevron. I think Chevron deserved to die, and I'm very happy it's dead, and the fact that it's dead makes me extremely incredibly happy. I'm all the happy. It's fantastic. I can't begin to tell you how happy I am by the death of Chevron because of how fantastic it is. It is just truly that glorious. But we are going to respond to his thing and see what he has to say about this thing. So, okay, I have not watched any of this video. I've not watched any of the video. The only thing I've literally seen up to this moment, the only thing I've seen is the thumbnail. And the thumbnail alone is like the price of admission. I'm excited. I'm excited about this. Okay. All right. Let's drink some sweet milk of some sweet tears. Let's go ahead and watch this thing. They did just kill it, and it's a relatively big deal. How big a deal it is depends on who you ask. I think in the end it will probably be something on the margins. But Andrea Burkhart, who I respect endlessly, thinks it's more than the margins, which maybe she's right about that. That'd be nice. And we'll see. No audio in the video. Okay, that's fine. I can fix that. No problem. We'll go back to the beginning. We'll listen to the whole thing. It's fine.
And the Supreme Court has destroyed the entire federal government. Well, that's only slight hyperbole. Maybe just the entire administrative state. Now, you might have heard of Chevron or Chevron deference. Well, the Supreme Court just killed it, and that's a big deal.
Yeah, they sure did.
It's a huge deal. It's one of those things that generally you have to be in the know to understand. But it would be like if the Supreme Court just said all briefs must be filed in Latin. Maybe it won't affect you on an everyday basis, but it really screws up the judicial system, and it's going to be a pain in the ass for lawyers and judges going forward. Now, to understand this massive decision, you need to...
It's going to be fantastic for the lawyers going forward. It's going to be great because now the lawyers actually have the opportunity to actually try to challenge some of this stuff, and it's going to be fantastic. It's going to be great and awesome and wonderful in every possible way. My thrill level is unmatched of how great this is. Yeah. Oh, I need to. Yeah. Okay. All right. So let's watch some more of this. This is good shit. All right. All right.
A quick primer on administrative law. Here's 3 things you need to know. First, Congress passes laws, and generally courts interpret those laws because sometimes those laws are ambiguous. A lot of those laws establish or empower federal agencies because the government is big and does a lot of stuff. And finally, a ton of what those agencies do is highly technical or scientific. So sometimes Congress intentionally leaves laws ambiguous so those agencies can do their jobs. And Chevron deference is all about what happens when a federal agency deals with an ambiguous law. And chaos lawyer Liz Dye has more on this catastrophe.
Thanks, Devin. The Supreme Court has executed its biggest power grab in decades, and it's all thanks to a tiny little fish. Yes, the nation's high court issued a joint holding in 2 cases known as Loper Bright Enterprises versus Gina Raimondo, the Secretary of the Department of Commerce, and Relentless, Inc., v. Department of Commerce, both of which involved regulation of herring fishing in ocean waters. The ruling, which overturns a long-standing principle known as Chevron deference, paves the...
Chevron deference is stupid. Chevron deference is incredibly stupid. It makes no sense, man. It makes no sense. It's up to the legislature to define things. It's up to the judicial branch to interpret them. The executive branch doesn't get to interpret laws. It's incredibly, incredibly dumb. The stupid is incredibly real. Yeah, I don't believe any of this thing. Yeah.
Way for courts to rewrite administrative regulations more or less at will. So now judges can overrule those pesky experts on stuff like what constitutes a distinct population segment under the Endangered Species Act? When does an alpha amino acid polymer qualify as a biological product under the Public Health Services Act? Or how much airplane noise reduction is sufficient to substantially restore the natural quiet of the Grand Canyon under the 1987 Overflights Act?
Those all sound like legal questions to me. Those all sound like legal questions to me. Congress could define it, and sometimes they leave things open. And then you got to figure it out. Like, what does it mean? And the way that you do that is through legal interpretation. The problem was the executive branch was the one that got to interpret it. And also, thanks to cases like Brand X, they got to change their mind. So they got to say, oh, this, for example, natural quiet. What does that mean? Like, one administration could say it's this, another administration could say it's this complete opposite thing, and they'd both be right. But now that's no longer the case. Now there's like only one definition. And the one definition will rule them all, from administration to administration. It promotes greater consistency, incidentally. And it also means that the legislature actually, has to legislate and stuff. So that's nice. That's nice.
Those three examples come from the dissent authored by Justice Elena Kagan and joined by her fellow liberal justices Sonia Sotomayor and Ketanji Brown Jackson. As Kagan notes, the majority's holding in Loper Bright allows courts to substitute their judgment for that of scientists and policy wonks who certainly know more about the topic than federal judges. And that represents
not more on the law, though. Not more on the law, because it's ultimately a legal question. What does it mean? It's a legal question. No, they don't know more.
a massive shift of power away from the executive branch to the judiciary. It all started in 1977 when Congress amended the Clean Air Act to force polluters to submit to a permitting process known as new source review every time they wanted to construct a new stationary source of pollution. Under President Jimmy Carter, the Environmental Protection Agency interpreted the law to require permits for every new smokestack. So, to be clear, Congress did its job and enacted a law, and then the executive branch implemented it through rules and regulations, which is its job.
Yeah. So the question in Chevron versus NRDC, the question is, what is a stationary source of pollution? That was the question. And we've discussed this before, right? We've discussed this as a couple different ideas. Like maybe a furnace is a stationary source of pollution. Maybe a smokestack is a stationary source of pollution. Maybe the entire power plant is a stationary source of pollution. Maybe some sort of collection of power plants is a stationary source, depending on how they're, organized, right? If the power plant is divided by a road, for example, is that one power plant or is it two, for example? So how would you go about defining that? And that was the question. What is the stationary source of pollution? And Carter had an idea. It's like, okay, maybe it's the smokestack, which is a reasonable idea. It's a reasonable idea. It surely is. But there are competing interpretations. And so the question is, well, which interpretation is best interpretation? Which sounds like suspiciously like you should go to court and figure it out, which interpretation is best interpretation as a matter of law. And the EPA might have thoughts on this issue, and their thoughts can be informative, just like anyone else's thoughts can be informative. But they're never controlling. That's the thing. It's ultimately the opinion of the court. So the EPA may win in the end, and that's fine. But then it's like, well, you're stuck with that interpretation because that's what the law means. Yeah, totally fine.
When President Reagan was elected in 1980, his EPA took a different approach. It decided that new source review was only triggered if the improvement increased the amount of pollution in the bubble of the entire project. So a factory could install a new, highly polluting modification without a permit so long as its overall emissions didn't go up.
Right. So that is exactly it, right? Carter said, how about the smokestack? Reagan said, okay, how about the entire plant? And there are advantages and disadvantages from an environmental standpoint from doing it this way. So it's not necessarily inherently obvious which is even the best environmental approach. Maybe looking at the entire plant level provides greater flexibility. So there are reasons to do this, like on either level. There's philosophical reasons, even from an environmental perspective, to pick one over the other. But it's like, let's just pick one and go with it. If Congress wants to change it, they can do it. That'd be fine. So yeah, Reagan said, how about the power plant level? Which maybe that's the right answer too. Let's just pick one.
Defeating the purpose of the Clean Air Act amendments, which were intended to force new construction that reduced pollution overall. In 1980,
she sort of contradicts herself there. She says it undoes the purpose of the Clean Air Act, which was to reduce pollution overall. But those are mutually inconsistent thoughts, because Reagan was like, how about overall? So, yeah.
The National Resources Defense Council sued the EPA in federal court in D.C. That case was captioned NRDC versus Gorsuch because the nominal defendant was EPA Administrator Ann M. Gorsuch, the mother of future Supreme Court Justice Neil Gorsuch. In an opinion authored by future Supreme Court Justice Ruth Bader Ginsburg, the D.C. Circuit invalidated the rule change because it conflicted with both precedent and the stated purpose of the statute, which was to reduce pollution. The Chevron Corporation, an oil behemoth whose interest did not lie in cleaning up the environment, intervened, and by the time the case landed at the Supreme Court, it had been rechristened Chevron USA versus NRDC. Writing for a unanimous court, Justice John Paul Stevens reversed the D.C. Circuit, articulating what was known for the past 40 years as the Chevron Doctrine, or Chevron deference. Under Chevron, courts conducted a three-part test when faced with a challenge to an executive agency's interpretation of federal law. First, the courts examined the statute authorizing the agency action to see if its language was ambiguous. If there was ambiguity, it was presumed that the agency was authorized to make rules to fill any gap left implicitly or explicitly by Congress.
No. That's the problem, right? It's like, okay, if it's ambiguous, it's up to the agency to create a rule. But the problem was that they were making rules that were completely contradictory with each other. And they allowed for this completely open flexibility, which, by the way, meant that like both Reagan and Carter were right, incidentally, under Chevron. Both Reagan and Carter were right, which is kind of the problem from my point of view, right? Because, you know, as Reagan gets replaced by, you know, Bush, who gets replaced by, you know, Clinton, who gets replaced by, you know, as you go back and forth, it's like we're just bouncing all around as opposed to having a steady interpretation. So, yeah, but no, the agency, if there's a gap and they give discretion, then maybe it is for the agency. But the problem is it became a really default answer. And so it gave the agencies way too much power. It's some bullshit.
That gap constituted an express delegation of authority to the agency to elucidate a specific provision of the statute by regulation. Second, the court assessed whether the challenged agency interpretation was reasonable. And if so, courts would defer to that interpretation, hence the name Chevron deference. Only if the agency's interpretation was unreasonable would courts rewrite agency regulations so as to make them comply with the law.
And as a practical matter, that almost never happened, because it was incredibly hard, because, you know, you get lawyers involved and they can make anything sound reasonable pretty much. So trying to overturn an agency with Chevron deference was basically impossible, which meant that they gave everything that they wanted all the time. So, yeah.
Justice Stevens noted that judges are not experts in the field and are not part of either political branch of the government. When a challenge to an agency construction of a statutory provision, fairly conceptualized, really centers on the wisdom of the agency's position rather than whether it is a reasonable choice within a gap left open by Congress, the challenge must fail. In Chevron versus NRDC, this meant that the EPA was free to water down the standards of the Clean Air Act and let corporations continue to pollute the air. But
right. So from her point of view, as you just said, right, her point of view is that Reagan was wrong on the interpretation, but Chevron was the thing that allowed him to do that, because she thinks that Carter's interpretation was superior, which I don't really have a strong opinion on one way or the other. You know, it's been a long time since I've delved into the details, but last time I delved into the details, it seemed to me that there were arguments both way from an environmental perspective for various interpretations. It wasn't inherently obvious that one interpretation was inherently better than the other. But she's of the opinion that Reagan's interpretation was bad. Okay. Well, if you don't give him the deference to make the decision, and you're like, no, this is the right legal answer, whatever the right legal answer is, then you'll get what you want, or more to the point, what Congress wanted. So, yeah.
In practice, this gave presidential agencies broad power to interpret federal law and enact regulations that reflected the administration's political priorities. For example, the Trump and Biden administrations took radically different approaches to whether Title IX's prohibition on discrimination because of sex required sports teams to include or exclude transgender athletes. Since the Chevron decision came down in 1984, conservatives took control of the judiciary, solidifying a 6-seat majority on the Supreme Supreme Court and seating the federal bench with loads of federal judges selected from the conservative movement specifically to oppose liberal policies. Meanwhile, as the country became ever more sharply divided, Congress has become ever less effective, passing fewer and fewer laws. With Congress...
Yeah, but part of the reason that they might be less effective, or at least part of the reason, is because they don't have to be. Because now the administrative agencies can just do everything. So Congress doesn't even have to Congress. Which makes you wonder why you're voting for them in the first place. So you've now effectively replaced Congress with a bunch of unelected bureaucrats. You've replaced Article 1 of the Constitution with Article 2 by impact. So that seems like a really, really bad plan. So let's not do that.
Functionally broken, presidents have come to rely more and more on executive action and rulemaking. And so, overturning Chevron became one of the main goals of the conservative movement, allowing them to more easily challenge executive actions by Democratic administrations without the annoying obligation to defer to an agency's interpretation of laws. In 2020, Justice...
That's the thing. That's exactly the thing. Deferring to the agency's interpretation of law. That's the thing. That's the thing. That's the problem. Why would you defer to an agency's interpretation of law? That's the problem, right? I'm not necessarily opposed to the concept that Congress may have given an agency broad authority in some domain. That might be the correct legal interpretation. If it's the correct legal interpretation, then fine. Congress wanted to give them broad authority, then cool. But that's the right legal determination. So why would you ever defer to an agency's legal interpretation? Because the agencies have no expertise or no specialized expertise when it comes to the interpretation of law. That's exactly why we invented Article 3 courts in the first place. It says so right in Article 3, right? The Supreme Court shall be the court with respect to all issues of law or equity. That's what they were talking about. So the Supreme Court, and to the same degree the federal courts, more generally speaking, are supposed to interpret the law. So why would you ever defer to the federal agency? Maybe they're right, maybe they're not. But it's a legal call. It doesn't rely on any specialized understanding of the facts. So, yeah.
Thomas wrote that Chevron compels judges to abdicate the judicial power without constitutional sanction and gives federal agencies unconstitutional power. In
Pretty much that, yes.
2022, Justice Gorsuch warned that the doctrine poses a serious threat to some of our most fundamental commitments as judges and courts and deserves a tombstone no one can miss. And so it was clear that Chevron, like Roe v. Wade, was doomed. Although it wasn't obvious that Chevron would be toppled by a tiny little fish.
Now, obviously, if you're going to challenge the entire administrative state, you're going to need a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help.
Warren Magnuson and Republican Senator Ted Stevens. The law established 8 regional fishery management councils dedicated to protecting commercial fishing stocks. The councils were vested with various powers, including authority to require that one or more observers be carried on board a vessel for the purpose of collecting data necessary for the conservation and management of the fishery. And it was that power.
Yeah. Incidentally, by one or more observers, they mean an official from the government that would have to be on your boat. That incidentally, you, the boat owner, might have to pay for their salary. Because that was part of the issue. That was part of the issue. Not only do we want you to be forced to carry this government official on your boat, your personal boat, but also you have to pay them their salary for the privilege. So yeah, some people had some thoughts about that issue.
Enumerated in 16 U.S.C. Section 1853b, which wound up taking out the edifice that held up administrative law in this country for 40 years, because the law did not specify how those observers were to be funded. Or, to be more precise, it did, but not super clearly. Section 1855 contained a general implementing clause authorizing the Secretary of the Department of Commerce to promulgate such regulations as may be necessary to discharge such responsibility.
So, yeah, okay. So it didn't say how they're supposed to be funded, but there is this general provision. It says, hey, the secretary can put forward any regulation That might be necessary. So it doesn't say how they're supposed to be funded. How about this? How about you, the boat owner, pay for the government employee's salary to be on your boat? So your Fourth Amendment interests disappear, by the way, because they're there on your boats. So goodbye, Fourth Amendment. What little of it was left on boats anyway, but I digress. And also you have to pay for their privilege. So see, people have some problems with that.
To carry out any other provision of the Act. And Section 1858G allowed the councils to punish any vessel owner for failing to pay for the observer's services, which would
fail to pay for the observer's services. In other words, the vessel owner has to pay for the government employee. Yeah.
strongly imply that Congress intended the councils to be able to charge boats for the observers. And that was certainly the position taken by Donald Trump's Secretary of Commerce, Wilbur Ross. But it was not the position taken by a company called Loper Bright Enterprises, which sued the Department of Commerce in February of 2020, calling the regulation an unlawful mandate by the federal government that requires herring fishermen along the eastern seaboard of the United States to carry National Oceanic and Atmospheric Administration contractors, called at-sea monitors, on their vessels during fishing trips, and moreover to pay out of pocket for costs associated with allowing these government contractors to monitor their fishing activity.
You pay for the federal employee to be on your boat. Oh, I'm sorry. Did I say employee? I meant contractor, like it makes a difference. But yeah.
2 weeks later, a similar lawsuit was filed by a commercial fishing company under the caption Relentless Inc. v. Ross. Now here's a fun tip. When you're trying to figure out why a lawsuit was filed, skip to the signature block and Google the lawyers who put their names on it. The Loper Bright case was brought by Ryan Mulvey and Eric Bolender, two lawyers from the group Americans for Prosperity, which was set up by billionaire brothers Charles and David Koch to combat climate legislation, unions, and minimum wage laws, and generally fight all progressive policies. And the Relentless case was brought by lawyers from the New Civil Liberties Alliance, another group funded by the Koch brothers to attack government regulations, which is a pretty good indication that the fish here was just a big old red herring. These cases were always torpedoes aimed straight at the Chevron.
As opposed to all the liberal people who have been filing lawsuits on their end for the advancement of their causes. But if the conservatives do it, it's really, really bad, you see. So when the liberals and the progressives have been funding various agencies and, think tanks and policy groups and whatever to file lawsuits to get the law changed or recognized in their direction, that's really, really good. But if it's the conservatives doing it, it's really, really bad. So that's how that plays out. That makes sense. Yeah, okay. But it's those Koch brothers who are paying for legal advocacy. Okay, all right, sure.
Chevron doctrine, and they scored a direct hit. The plaintiffs lost at the trial courts in D.C. and Rhode Island, and then lost again at the D.C. and First Circuits. And by the time they wound up at the Supreme Court, the only question being considered was whether the court should overrule Chevron, or at least clarify that statutory silence concerning controversial powers expressly but narrowly granted elsewhere in the statute does not constitute an ambiguity requiring deference to the agency. In short, the justices had given up the red herring and were aiming straight for the iceberg.
Iceberg, right ahead! Thank you.
Chief Justice Roberts wrote the opinion for the court's 6 conservatives, framing the reversal of Chevron as the righteous repudiation of a grievous error. In his telling, Chevron ushered in a 4-decade period of judicial laziness where courts abdicated their responsibilities under the Constitution.
Pretty much. Because trying to overrule a agency on Chevron deference was really, really hard. Because you basically wound up in the position where you had to find a piece of statute that said exactly the opposite of what the agency was doing. So it's like, the reason they can't do it is because of this statute, which says exactly the opposite of that thing in exactly those words. And even then the agency would argue against you. But it got to the point where the agency could decide what the law is, and they could overrule the courts of appeal and do anything else they wanted. So yeah, that makes sense.
He said, when faced with a statutory ambiguity, the ambiguity is not a delegation to anybody, and a court is not somehow relieved of its obligation to independently interpret the statute.
Right.
He quoted Chief Justice John Marshall from 1803 saying in Marbury v. Madison that it is emphatically the province and duty of the judicial department to say what the law is.
Yeah. Yeah. Literally a quote so important, it's chiseled in the stone at the Supreme Court. The judicial branch gets to decide what law it is. It's in the Constitution. It's in Article 3. The Supreme Court gets to be the court that decides all matters of law and equity. That's what they do. So yeah, that would be the correct way to go. Yep.
He quoted the Federalist Papers, noting that the framers also envisioned that the final interpretation of the laws would be the proper and peculiar province of the court.
Yep.
He also quoted the Administrative Procedure Act, which was originally passed in 1946 and specifies that courts, not agencies, will decide all relevant questions of law.
Yep.
He referenced various respected commentators who endorsed his
I like how she's being so dismissive of all these quotes. I just find that hilarious. It's like, well, here's what here's what Chief Justice Marshall said in Marbury versus Madison. Here's what the founders said in the Federalist Papers. Here's what the Administrative Procedures Act says in its own terms. And she's just like, well, here's what they said. It's amazing how she's being so dismissive of all this pretty reasonable authority. It's pretty funny.
position that only the court can interpret a law and that the court owes respect, but not deference, to the executive branch agencies charged with actually carrying it out. And he cited various attempts by his own court to water down the holding in the past 20 years as evidence that the Chevron test imposes a dizzying breakdance on the courts and is wholly unworkable. He even sneered at the bare quorum of 6 justices who decided Chevron since Justices Marshall, Rehnquist, and O'Connor recused themselves. It's an odd way to describe a unanimous opinion, particularly since Roberts himself is speaking for just 6 justices. And it's
well, I mean, I don't know if it's that odd to be, this opinion was only heard by a court of 6 people. As opposed to a court of 9 people. So, I mean, that's, something. I mean, it doesn't make it less legally valid. The minimum, by the way, is 6. It's in statute. So the quorum for the Supreme Court is 6, not 5. So, yeah, 6 is the bare minimum you need. And so it's like, well, there's only a bare minimum of justices sitting on this case. So it's a little bit weird. Maybe that suggests it might not have necessarily been the best decision possible. So, okay. All right, fine.
It's especially odd in a holding where Justice Gorsuch's own mother was the defendant in the case being overturned. The majority's opinion boils down to this. In every case where a statute is ambiguous, there must be a best reading of the law, and courts are obligated to use every tool at their disposal to determine the best reading of the statute and resolve the ambiguity themselves, rather than letting the experts, tasked by Congress and the voters, fill in the blanks. But as Justice Kagan's dissent for the court's 3 liberals points out, sometimes statutes are just sloppily drafted, and there is no best answer for a blank Congress forgot to fill in. And if there is a best answer, it's probably not going to be arrived at by courts applying general principles of law. In fact, it may not be a question of law at all. The Chief Justice...
What? Okay, let me make sure I got this straight. Under your idea, because this concept blows my mind. And I'm going to struggle to try to understand it for a second. Okay, the premise is that Congress sometimes writes laws that are vague and unclear. Okay. And sometimes there might not necessarily be like a best interpretation. It's like, okay. And then she goes for the throat and says, well, then it's not even a question of law at all. What? Yes, it is. It literally is a question of law. Maybe the answer is a little bit unclear. Or maybe the answer is subject to more debate. But the question is still the same question. How could it not be a question of law? Her premise is Congress has passed a statute, right? That was her premise. And so how could doubt and ambiguity about that not be a question of law? Does that make sense to anyone else? I don't even know what she's trying to say. If she's trying to say that maybe the interpretation should be a wide interpretation, then maybe that's true. I mean, maybe the best interpretation is a wide interpretation, because maybe Congress left it open, and maybe the best interpretation is wide. So she means that, in some cases, it might be the case that it makes no difference whether you have Chevron deference or not, right? Then she's probably right. I mean, because the agency could be right in the first instance. Just because the agency is advocating for it doesn't mean they're wrong. It just means that they're not God, which is the change. So it will be the case, and I imagine more frequently than not, that the agency will propose an idea and the courts will be like, okay. But the thing is that will just be the interpretation now, which will clarify the issue, and then Congress can change it if they want. And to the extent that I don't know what she means, it's not a question of law. I don't know what that means. I don't know what that means. I don't know what that means. I'm very confused.
Yada, yada, yada is that Congress expects courts to handle technical statutory questions. But that's a particularly ironic thing to say on the same day when Justice Gorsuch dropped an opinion in which he confused nitrogen oxide, a greenhouse gas, with nitrous oxide, better known as laughing gas. Because there isn't a balls and strikes answer to every technical question of administrative procedure. And Justice Elena Kagan made this point by highlighting a bunch of cases decided on the basis of Chevron deference, like Teva Pharmaceuticals versus the FDA, which turns on the question of when does an alpha amino acid polymer qualify as a protein, or what does distinct mean when you're talking about various populations of endangered squirrels. That was the issue in Northwest Ecosystem Alliance versus U.S. Fish and Wildlife Services. Or what does a geographic area mean when you're talking about Medicare reimbursement rates? See Bellevue Hospital Center v. Levitt. I'm a lawyer and a reasonably smart person, and I don't know the answer to those questions. And neither did the federal judges who decided those cases, because there wasn't one best answer for the court to divine by scrutinizing the statute and applying principles of law.
Right, but in such a situation, we make a decision as judiciary, and then that just becomes the answer. So there might be more than one possible valid legal interpretation. And even to a reasonable jurist. I've certainly been in that position before, where even like on a question of law, I've been like, I could go this way or I could go this way. And sometimes it's even contradictory, because sometimes it's open to interpretation. But the thing is that you pick something, and one of the things you do is you have the district courts make decisions, and then they get up to the Court of Appeals, and then if the Court of Appeals disagree, then it goes up to the Supreme Court to make the ultimate decision. And if Congress doesn't like that answer, then Congress can overrule the Supreme Court. So, okay.
Congress writes laws, which are pretty general, and leaves it to the executive to carry them out, which is why the judges deferred to the federal agencies that administer the Food, Drug, and Cosmetics Act and the Endangered Species Act and the Medicare Act to define those terms. But according to Chief Justice...
Which, incidentally, maybe that's the correct interpretation in those cases. I don't know. I haven't thought them through individually, but maybe the correct interpretation is Congress wanted it to be flexible. And maybe they wanted the executive agency to change its mind from time to time. Maybe that's what Congress wanted. Maybe they wanted a flexible thing, and they wanted the administration to be able to change it. But either way, that's what Congress wanted. So you're just saying, okay, Congress wanted the agency to be able to say A and say not A, and both answers are correct, and that's what Congress wanted. You know, and there's a lot of situations in which that might be true. All right. If, for example, you had a law that said Congress shall be, or the agency shall be able to determine what the grazing rights are on a piece of public land, well, maybe none is the right answer. Or maybe all is the right answer, or somewhere in between. And maybe that answer changes depending on administrative preference and environmental factors and a whole number of things. So maybe it can be an extreme, but even then you're just like saying, okay, that's what Congress wanted, and that's the correct interpretation. And if Congress wants something more constricted, they can pick something. And if they did choose something more constricted, let's do that. You're just faithfully applying the law. So maybe it's the correct answer in those cases. I don't know. Maybe it's the correct answer that without Chevron, they'd come out the same. I have no idea. Maybe that's the right answer, but it's a legal question. I'm pretty sure of that.
Justice Roberts, it's actually the court's job to grab a pen and mark up a statute anytime the law is unclear. He wrote, "It therefore makes no sense to speak of a permissible interpretation that is not the one the court, after applying all relevant interpretive tools, concludes is best. In the business of statutory interpretation, if it is not the best, it is not permissible."
That line is hard to draw in some cases. I would say not in most cases, and make sure that this is the question that you, the judge, are supposed to be deciding rather than someone else.
And it's certainly not what he said about the foundational doctrine of stare decisis, or at least it's not what he used to say. Stare decisis is a Latin term meaning to stand by things already decided.
Yeah.
In law, it means that precedent is binding on subsequent courts. And once an issue has been ruled on, that is the law of the land. And while the Supreme Court can overturn precedent, there has always been a strong institutional taboo against doing it because it makes the justices seem like partisans who rule based on their own policy preferences. But precedent is also important because we all rely on knowing what the law is. And if that law is constantly changing, then it can cause major civic and social instability.
Please disperse. Nothing to see here, please.
But Donald Trump's election prompted a major sea change. He was able to name 3 justices decisively swinging the Supreme Court to the right, at which point conservatives got a whole lot less concerned about stare decisis. So during their confirmation hearings, Justices Kavanaugh and Gorsuch mumbled a little bit about Roe v. Wade being settled law before immediately voting to overturn it in the Dobbs case. Since then, senators have switched to asking judicial nominees whether Brown v. Board of Education, the seminal school desegregation case, is settled law, with alarming results.
Yes. Very.
Do you believe that Brown versus Board of Education was correctly decided?
Senator, I don't mean to be coy, but I think I get into a difficult area when I start commenting on Supreme Court decisions which are correctly decided and which I may disagree with.
Yeah, so the problem isn't Brown versus Board. She's thinking ahead because she's intelligent. And she knows that if she says Brown versus Board was correctly decided, that suddenly they're going to ask her about other cases. And then if she says, well, I can't possibly comment on it, people are like, well, you commented about Brown versus Board. Why can't you comment about this? Right? So it becomes much easier just to be like, well, I'm not going to comment about any of them because I don't want to open the door. Right? I'm just not going to open the door. Be like, yeah, I'm not going to answer that question because then you're going to ask me about the next case, the next case, the next case. And suddenly I'm going to have to give opinions about every Supreme Court case. And if I deflect, you're going to be like, well, why is this time different? So she's thinking ahead. And Justice Ginsburg did the exact same thing. Justice Ginsburg is incidentally probably the justice most responsible for starting this trend. She's the one who basically gave the I can't possibly comment on any case kind of answer. So that's kind of normal.
Yikes. There is just no argument that Chevron was anything other than settled law. As Justice Kagan noted in her dissent, the doctrine has been applied in thousands of judicial decisions. It has become a part of the warp and woof of modern government, supporting regulatory efforts of all kinds, to name a few: keeping air and water clean, food and drug safe, and financial markets honest. Overturning it requires total disregard for stare decisis and more than a wee smidge of judicial arrogance. Luckily,
no, because as you noted, it goes back all the way back to Marbury versus Madison. It's exactly the province of judicial departments say what the law is. It goes back to the Federalist Papers. It goes back to the Administrative Procedures Act, and be like, no, we just got it completely wrong. Screwed that one up. Poached it hard. You know? Yeah. So, no.
Justice Gorsuch was happy to oblige. In a 34-page concurrence, he praised the majority for its brave act of judicial humility in conceding that its own precedent was wrongly decided. Then he celebrated the tombstone on Chevron no one can miss, calling back to his own earlier writing, as all truly humble jurists do. Along the way, he rubbished the idea of stare decisis generally, noting that in the 18th century, common law judges did not, broadly speaking, afford overwhelming weight to any, quote, single precedent.
Yeah, so the question of stare decisis, more broadly speaking, is obviously a bit of a philosophical question, and there's no really great answer to this, to be honest, on this issue. There's really no great answer to this. You could say that stare decisis shouldn't ever be a thing, but at that point, you're just a civil law system because you have no stare decisis. And you could say it's always a thing, but well, that's really a problem for obvious reasons. So, you obviously need the ability to get rid of stare decisis, and there's really no great principled answer I've ever heard for where to do this and where not to do this. And different people will think about it differently. Some people will be like stare decisis should have more effect, and some people will be like it should have less. And there's really no great answer to this from first principles for anybody, incidentally, left or right, that I've ever heard of. So how you just say, well, it doesn't apply when I don't want to apply, I don't know. But yeah.
And in ye olde England, a judge's decision might bind the parties to the case at hand, but none of that meant the judge had the power to make a law properly so called for society at large. For that, only the king and parliament can do. The Chief Justice wasn't willing to go quite that far, but that's why he spent so much time talking about Marbury v. Madison and pre-Chevron practice while claiming that Chevron was totally unworkable and forced judges to breakdance or whatever. Because if you say, well, this law was working fine for 4 decades, but
it wasn't really working that well. It wound up being a massive power grab by the executive. It wasn't really working that well. She loves the administrative state, though. She's ready to get down and worship the administrative state, man. Boy, oh boy. Boy, oh boy. She's ready, man. Okay.
we didn't like it, and now we have the votes to overturn it, so we did. It sounds kind of bad. Or as Justice Kagan put it, this court has avoided deferring under Chevron since 2016 because it has been preparing to overrule Chevron since around that time. That kind of self-help on the way to reversing precedent has become almost routine at this court. Stop applying a decision where one should, throw some gratuitous criticisms into a couple opinions, issue a few separate writings questioning the decision's premises, give the whole process a few years, and voila, you have a justification for overruling the decision. Ouch. But Justice Kagan wasn't done pointing out the hypocrisy.
God, could she be like any more smug in her presentation? She's like so smarmy. She's so like smarmy and condescending and infantilizing. Jeez, Lord, man. It's like, shit, dude.
She observed that the majority cannot destroy one doctrine of judicial humility without making a laughingstock of the second. That is, the majority was so excited to ditch the Chevron doctrine and substitute their own opinions for those of government experts that it
There is no such thing as a government expert when it comes to a question of law. If you tell me, and if you try to tell me that what a statute means is not a question of law again, I'm going to slap you in the face from across the internet. Because no.
trampled the doctrine of stare decisis and showed their whole herring to the world. She added that if opinions had titles, a good candidate for today's would be hubris squared. In his holding, the Chief Justice went out of his way to minimize the chaos that this ruling will unleash. He offered assurances that all the previous decisions made based on Chevron doctrine are still good law, and the holdings of those cases that specific agency actions are lawful, including the Clean Air Act holding of Chevron itself, are still subject to statutory stare decisis, despite our change in interpretive methodology.
Which, fair enough. Fair enough. He's like, for better or worse, we've been operating this way, and we're going to only make a forward-looking decision. Which, I don't really have a particular problem with. I don't have a particular problem with. It's like, okay, we're just going to do this in a forward-looking way, so all the past decisions are right, and if you want to change anything, then we're going to do this going forward. It's like, okay, so you don't upend 40 years of it decisions. And now you just like, okay, well, now going forward, don't do Chevron anymore. Like, all right, that's fine. The Supreme Court, like any court, can do remedies. And sometimes remedies are only forward looking. It's like, well, we're not going to fix the past, but going forward, here's what we're going to do. It's like, okay. Sometimes that's the right answer. Makes sense to me.
But it cannot be overstated what an earthquake this will be for administrative law.
I don't really think it's going to be that much an earthquake, personally. Andrea Burkhart disagrees with me. Donnie on Direct disagrees with me. And this lady, whoever she is, disagrees with me. I hope they're right instead of me. I think this Chevron will ultimately wind up being a marginal decision. I think ultimately it's only going to make a difference on like 5% of the cases or 10% of the cases. Because it's only going to be in those cases where they're like, pressing the limits and where they could try to get away with this. But she thinks it's going to be an earthquake. So if it winds up being more significant than I thought, then that's fine by me. Then if it hurts the administrative state, then fine by me. So I've been relatively conservative in what I think is going to happen. But if I'm wrong, hey, that works for me too. So from your lips to God's ears, mate, lady.
If the EPA wants to regulate industry to cut pollution, or the FDA wants to ban harmful additives, or the Labor Department wants to set standards for overtime rules, or the Federal Reserve wants to limit credit card swipe fees, all those things will be challenged. In fact, that last one is not a hypothetical. In a case called Corner Post Inc. v. Federal Reserve Board of Governors, decided on the last day of the term, the Supreme Court effectively abolished the statute of limitations for challenges to an administrative regulation.
Which was a really nice little touch. I like this decision. This was the day after Chevron, and I like this decision a lot too. Basically, it means the statute of limitations to challenge administrative action resets with respect to each person, as opposed to it being from the time of the regulation. So if there was a regulation passed in 1975, I guess, whatever, it doesn't matter. But like the period to challenge that has long since expired. Right, under the Administrative Procedures Act, the period to challenge that has long since expired. But in this case, they're like, well, no, not so much. Well, no, the period to challenge the regulation itself has long since expired. That's still true. But once they start to apply it to you, now you have a statute of limitations because now the clock is running with respect to you. You didn't have an injury before, remember? Like you've just been going along your whole life, la-di-da, and for whatever reason, now this federal agency has a boot up your ass. So you didn't have standing before to bring a challenge. And now suddenly you do. And before they're like, well, you can't bring a challenge because the period of challenge is long since expired. But it's like, but I've just been injured now by your regulation. It just started impacting me just this second. I didn't have standing yesterday. I couldn't have brought it in if I wanted to. And so the Supreme Court's like, oh, that doesn't make sense. So every person can challenge the regulation. Now, from the moment it starts to apply to you is when the clock starts ticking to bring your challenge. And, you can bring it as an as-applied challenge, which is fair enough. And if you want to bring it as a facial challenge, maybe you could try that too. But yeah, that was a pretty big decision because it means, well, the federal government puts their boot up someone's ass every single day. Someone every single day gets a letter from the federal government of an agency that they never before contemplated this moment. And now suddenly wants to boot up their ass. So now finally they have the ability to challenge it and possibly get the regulation overturned completely, which I thought was pretty hilarious. This decision was a bit of a sleeper one, but I'm here for it. I was definitely here for this decision.
Previously, a rule had to be challenged within 6 years of its enactment. Now, a party has 6 years.
Right. That's exactly right. See, that's the problem. That's what I was saying, right? So imagine that a rule got passed in 1975. So it's like, okay, you only have until 1981 to challenge it. And now imagine for the first time it starts to apply to you. And you're like, wait a second, I can't challenge it because I was supposed to challenge it in 1981. Some of you guys weren't even born yet. And I was supposed to challenge it in 1981. I don't know how that's supposed to happen. And it's like, oh no, now you can challenge it because the 6-year statute of limitations starts running from when it impacts you. Because now you have an injury that applies to you. So the statute of limitations starts running. Yeah.
From when it began being harmed to sue, meaning that a bank can set up shop tomorrow and challenge a rule that has been in place for decades because its harm is brand new. And
Correct. She says that in such a dismissive way too. Correct. If there was a new bank started tomorrow, then suddenly all these wonderful regulations that apply to banks would suddenly apply to them. It's not illegal to create a new bank. People do it all the time. Well, I mean, not all the time, but you know what I mean. I mean, people create new banks. And suddenly it's like, well, before yesterday, none of these exciting regulations apply to you. And now suddenly they do. And like, wait a second, these regulations aren't fair. I want to go challenge them. Well, now you can. Now you can. Let's go find out if they're legal or not. Yeah. And she says it in this smarmy way. Can you believe it? Can you believe this brand new bank has the power to challenge all the regulations that relate to banks and whether they're legal or not? Can you believe it? Like, yes, a little bit. I can believe it. Yes. I mean, that's what I think. Yeah, okay. Okay.
And as Vox's Ian Millhiser warns, Loper Bright makes the courts and ultimately the Supreme Court responsible for resolving thousands of low-stakes policy questions, which often cannot be resolved simply by reading the law's naked text.
Fair enough, which is true. This is true. It is hard and sometimes might be borderline impossible. And in some situations, the answer might be Congress just left it open. Maybe that's the right answer. But at least we know it's the right answer. And if we have to pick some other answer, then fine with that too. And if Congress doesn't like it, they can always change it. Congress might have to actually start doing their job. Film at 11.
The justices, in other words, can look forward to missing their children's basketball games, skipping out on date nights with their spouses, and not really doing much of anything at all besides deciding the crushing weight of cases that are about to land on their desks.
Look, first of all, look at this woman's face. Look at this woman's face. That's the face of smugness in spades. I know better than you. I know better than you. I'm a good lawyer. First of all, the Supreme Court isn't obligated to hear any case. And second of all, they'll hear cases that probably help to resolve issues in a broader sense. Most of these things will stop at the Court of Appeals level, which is where most of them stop anyway. Lady who smelled her own fart over here doesn't really approve of that, but you know, whatever.
Yeah, boo-hoo. A blog post by the Union of Concerned Scientists predicts that the end of Chevron will introduce a new level of difficulty into the regulatory process. Agencies like the EPA will need to try to anticipate every potential legal challenge alleging statutory ambiguity and prepare comprehensive justifications that can withstand unbounded judicial scrutiny.
Wow. Wow. Did you hear that? Did you hear that? Wow. So in the future, if the administrative agencies want to pass a regulation, they'll have to consider whether or not their regulation is authorized by the statute. And they can only act in accordance with the statute. Which, by the way, is exactly what is true for you and me and everyone else, by the way. You know, if you wanted to do a thing, whatever it is, you're going to have to figure out what the law means. And you better get it right, by the way, incidentally, because, you know, for you, there might be criminal penalties too. So the administrative agencies are now just like the rest of us. They're now just like the rest of us. They too will now have to figure out whether their actions are actually lawful or not. And they'll have to think it through and try to think about possible attacks on that so that they, you know, think about it so that they are complying with the law. Wow, the horror show. The administrative agencies will have to consider whether or not what they're doing is lawful or not. Wow. Okay.
This could slow down the implementation of new regulations, as agencies might take more time to ensure their rules can survive such legal challenges. Worse, agencies may decide not to even try.
Well, to the extent that they're trying to do things that are, let's see, extra legal, maybe. Yeah, some of them may not do things because they're like, we don't have the authority to do those things. Wow. Yeah. Amazing. The administrative agencies trying to follow the law. What a horror show that is.
All of which is very bad for people who like clean air and drinkable water and overtime pay and capping fees lenders can charge consumers and hot dogs without too much rat hair in them, and a million other tiny decisions which were previously made by experts and will now be subject to challenge by industry lawyers responsible to shareholders and special interests and not answerable to voters. But
you know who else is not answerable to voters? You know who else is not answerable to voters? The administrative agencies. Yeah, you didn't vote for any of these people. And for the vast majority of them, this is what Trump was talking about with the deep state. Because the administrative agencies have a tendency to survive political change because they're big things and it takes a long time to turn the ship, and they mostly don't even bother. So, yeah. So the administrative agencies now are also not supported by the voters, and they get to be challenged in court like everyone else does. They're just like the rest of us now. They're just like the rest of us and have to have their decisions potentially reviewed as to whether they're lawful or not. Wow.
on the plus side, Justice Gorsuch finally got that tombstone, so I guess it was worth it.
No.
Smug woman.
That was a great explanation, but I want to emphasize more about this 1-2 punch of Loper Bright and Corner Post, because frankly, Corner Post might be an even bigger deal than Loper Bright and the.
Yeah, I think it might very well be. It was a sleeper decision. I didn't see it coming, but it might wind up being a bigger decision because it means that people now can challenge Chevron. Like maybe not you. Maybe you can't. Oh, I apologize, not Chevron, but an administrative thing, right? So maybe you can't challenge it because maybe it doesn't apply to you yet, or maybe it's applied to you for too long. But somewhere, somewhere every day, a new person is being crowned as the person who has 6 years now. So maybe not you, but someone somewhere has been given this power because the administrative agencies try to put a boot up their ass and they get to fight back. So yeah, it might be a more consequential decision because it allows for more lawsuits. And now those lawsuits will have to be analyzed without Chevron deference. So that's exciting.
End of Chevron deference. Because it's possible the end of Chevron deference wouldn't have that big an effect on its own. In part because bad faith jurists have been claiming to apply Chevron deference for years, but basically just ignoring it and coming to outcome-oriented decisions.
Yeah, that's true. And the Supreme Court even noted that, by the way, which is part of the reason they overturned it. They sort of noted this because it's become completely unworkable, and a lot of judges have given up. And that's one of the reasons to overturn it, because it's unworkable. That's a standard reason to overturn stare decisis, by the way. Unworkability is a standard reason to overturn stare decisis if you need a reason. It's proved to be unworkable. And the judiciary has given up. They can't figure it out. So it's like, yeah. So it doesn't require you to be bad faith, by the way. It just requires you to be like, there's just too many contradictory things. I can't make it work. And even the Supreme Court's like, and the Supreme Court itself had not applied Chevron in 8 years, something like that. They hadn't applied Chevron because even they had given up trying to apply Chevron before they overruled it. So, yeah.
Have said that Chevron has been dead for a while, but now it's truly dead and judges will be the last and only word on ambiguous statutes. And with Corner Post, truly no federal regulation will ever be settled.
Yep.
Corner Post has effectively done away with the statute of limitations when it comes to federal regulations. And that's going to lead to an absolute deluge of litigation. I would not want to be a federal judge right now. They were already overworked and underpaid, and now they're going to be interpreting and reinterpreting regulations all the time. But of course, it's
I'm available to be a federal judge, by the way. If these people don't want the job because they can't be bothered to interpret and reinterpret federal regulations, I'm available for federal judge. I will happily interpret and reinterpret federal regulations. And I will do my best. And I genuinely mean this. I will do my best to give the effect that Congress wanted, which may be broad in some cases, but I'll do my best. And if they need somebody, I'm available. Just saying.
not going to be all courts. As we've already seen, there are a few judges, especially in the middle of nowhere, Texas, that love nothing more than to overturn current laws. So you're going to see thousands of newly minted corporations incorporated in Amarillo, Texas, challenging a regulation and then going before that company's preferred judge, just to overrule federal regulations. And additionally, because those judges are not subject matter experts, you're going to get a lot of wacky decisions. Not necessarily smaller government, but definitely weirder, less predictable government. We're going to get a whole weird...
No, it'll be more predictable. It'll be more predictable because the decisions will go through the normal appellate process under application of law, and they'll be more predictable because they won't change with the political winds. So no.
Patchwork of dueling interpretations and rules with inconsistencies between the states and circuits, and we're going to see a lot of junk science and cherry-picked history to get to outcome-oriented decisions. But if you're a federal judge who will be interpreting a whole bunch of technical regulations, you'll probably need to brush up on your math or science skills, which you can do with today's...
My math and science skills are fine. Thank you very much, because I have a computer science degree, so I'll be fine. Yeah, so no surprise. I continue to support the end of Chevron. And I continue to support, like, let's actually interpret the law and what it actually means. And let's stop with the Chevron deference. I have no problem giving the administration respect. I have no problem listening to their legal thoughts. They, and they have some technical knowledge that might inform their legal arguments that are worthy of consideration and might be even worthy of significant consideration. The major thing is that they're not controlling anymore, right? So my desire to give them respect, and even great respect, doesn't mean that they own me. It doesn't mean that they control me. And it means I can disagree with them if I think they're wrong. So let's go do that. I think it'll be fun. So yeah. So that's fun and exciting. So I enjoyed this, this stupid time over here on, over here and watching this thing. I hope you enjoyed it too. It was exciting and stupid. That woman, though, was so smarmy. That woman was so incredibly smarmy and derisive and condescending and infantilizing and so smug. She's a treat. She's a treat. So yeah. Legal Seagull bends over and squawks for the Minister of State. Pretty much, yes. Yeah. I don't have any particular thoughts about the federal judge in Alaska. If he broke the law and he did illegal things, then he deserves to be thrown out of office. So that's fine by me. You won't catch me disagreeing if it's true that the federal judge did improper things, and then he shouldn't be a federal judge. So, great. So, okay. All right, fine. That's fine. I don't really know anything about it. I just read a headline about it. So I don't really know anything about the judge. I just read a headline. I think he resigned recently from the federal bench, which, fair enough. So that's fine. You're happier about Chevron? Yeah, me too. This is, yeah. All right, I think I'm going to sign off for now and get some rest or something, and we'll see how it goes. And we'll be back on tomorrow with more of Alec Baldwin's trial. That should be fun and exciting. That should be good. So I will do that tomorrow, and I will see you then. Until later, my friends. I hope all's well. Cheers, my friends, for now, and goodbye.